We have a blockbuster day in Trump's New York criminal trial. His attorneys again moved for a mistrial, plus a major mistake that I think is going to cost them with the jury. We're going to cover all of that, but first, just a reminder that Glenn and I will be doing daily comprehensive coverage of this criminal trial in New York. First off, Trump's team wanted to preclude Karen McDougal, that's another woman he had an affair with, from testifying, and the news here is that the DA's office has notified the defense that it will not call Karen McDougal. So it seems like a win for the Trump team on its face. It seems like a bad development. What's your reaction to this, and is this good or bad news?
Yeah, it's actually not a win for the Trump team. It actually signals that the prosecutors are feeling even more confident about their case after the testimony of Stormy Daniels concluded. So let's unravel that. You know, I can't tell you how many times during a case I was prosecuting, Brian, that I had a very lengthy witness list. But as my witnesses began to testify one after another, and I saw that they were performing well, and I saw that the defense attorneys weren't really able to make any inroads on cross-examination, didn't damage their credibility, you know what I started doing? I started jettisoning witnesses, deciding I don't need to call as many witnesses as I originally anticipated calling. So I can almost promise you that when the prosecutors made the tactical decision that, you know what, we no longer need the testimony of Karen McDougal, it's a sign that they believe the quality and quantity of their evidence is strong. So this may on the surface or superficially seem like a win for Team Trump. I think it actually is a sign that the prosecutors are feeling really comfortable and confident in their case.
This was also the Trump team's second attempt in just so many days at declaring a mistrial. Why do they keep trying this move? Like, what do they have to gain? And could these desperate attempts actually hurt them?
Yeah, so I think they're trying to accomplish a couple of things. One, they're still playing to the court of public opinion. Every time there is a mistrial motion made, what happens? Everybody starts talking about it, mainstream media picks it up, and the signal goes out that, you know, something must be going sideways in the prosecution's case because the defense keeps moving for a mistrial. Well, the reality is nothing is going sideways, and you can tell that nothing's going sideways because Judge Merchan is summarily rejecting, denying mistrial motion after mistrial motion. The other reason they're making their motions is if the defense perceives that there is some new error that has been made, for example, by Judge Merchan in letting in a particular piece of evidence, well, then they want to object to it, and when the objection is overruled, they want to move for a mistrial just to preserve their ability to argue on appeal when the mistrial is denied. You know what? That was a legal error, and Judge Merchan should have granted the mistrial motion. So often, defense attorneys will object and will make any number of motions for relief, like a mistrial motion, simply to preserve the issue on appeal so they can argue it in the event their client is convicted and appeals his conviction. So, you know, none of this, I think, is of much consequence. It is kind of part of the trial dance that goes on in most criminal cases. Mistrial motions are made, mistrial motions are denied, and then the case continues to its conclusion.
Glenn, we heard earlier where Donald Trump's attorney was risking losing credibility with the court. Does doing something like this, these baseless efforts at declaring a mistrial, does that also contribute to him losing credibility with the court, or Trump's team more broadly losing credibility with the court?
Potentially. If the judge believes that they are absolutely frivolous motions, and if they become so repetitive that it's obvious that they're not doing it for any legal purpose, but really just to, you know, either maybe get it out into the court of public opinion, that will turn a judge against the defense attorney. Now, judges have to endure quite a bit, Brian, and they really are not supposed to take it out on counsel, even when counsel is sort of performing in a less than ideal way. But yes, you can irritate a judge, and the judge already up front told Todd Blanche, I think Donald Trump's lead defense attorney in this case, you are losing all credibility with the court. That really is like a dagger through the heart of a criminal litigator. I don't know if Todd Blanche was ever able to recover from that, but I don't think Blanche continuing to make frivolous mistrial motions will help dig him out of that credibility deficit in which he finds himself.
Now, Trump's attorneys also made a remark to Stormy Daniels while she was on the stand, and they were alleging that she, again, was just making everything up and that she and Trump never even had an affair. Here's Katie Fang's tweet. Trump's attorney said, "You changed your story many times because you never had an affair with President Trump." Stormy's attorney objected, and the objection was sustained. Glenn, how in the world is denying the most obvious part of this case, that they had an affair, a smart strategy for the Trump team? Because if Trump's team is telling the truth, then that would mean Stormy Daniels is just perjuring herself, which is a felony, every single day.
It's not a smart legal strategy for the Trump team. What it is the defense attorneys catering to an overbearing, unrealistic, micromanaging client. I am quite sure, we don't know this for a fact, but I would draw the reasonable inference that Trump told his lawyers, you go hard after Stormy Daniels, berate her, belittle her, call her names if you want, the way I do. I call her horseface. I mean, that's not going to endear Donald Trump to the jury, mocking a woman like that. But we've seen some New York Times reporting about what's going on behind the scenes. Donald Trump is venting that his defense attorneys aren't going hard enough after witnesses. They're not being aggressive enough. By extension, they're not being nasty enough. These are not legal strategies that the defense attorneys are deploying. These are the kind of things that a micromanaging client who knows nothing about the tactics of a criminal trial is telling his attorneys to do. I was reading some of the accounts of the cross-examination of Stormy Daniels, and I think it's Susan Necklace is asking her things like, you're really good about making up fake stories about sex on film, aren't you? And she said, oh, I assure you, the sex was real, just like what your client did to me in that hotel room was real. I mean, that kind of a comeback in a measured tone can really sting in the eyes of the jury. There was another great exchange where the defense attorney said to Stormy Daniels, well, this is not the first time a man made a pass at you, is it? She said, you know what? This is the first time a man twice my age, much bigger than me, with a security guard standing outside the door, made a pass at me. Again, answers like that, that's going to leave a mark.
Also, it does raise the question, if they're contending that she's lying, there is a way for Donald Trump to put his own neck on the line, and that's just to take the stand and testify what he's saying, which is that he never had an affair with Stormy Daniels. And yet, it doesn't seem like he's going to do that, so I'm sure the jury can infer something from that, correct?
No, they can infer nothing from a defendant who chooses not to testify. They cannot hold that against a defendant in any way, because every defendant has a Fifth Amendment right not to testify, not to incriminate himself. But they will be drawing conclusions. If the testimony of Stormy Daniels is largely unrebutted, right, under oath, she said over the course of 7 hours, you bet I had this encounter with Donald Trump. And there were some phone records backing up the fact that she had Trump's phone number and Trump's assistant had her phone number. But they're going to be drawing conclusions about Stormy Daniels' credibility and about what actually happened. But the one thing they can't do is say, well, we didn't hear from Donald Trump during the course of the trial, so we're going to hold that against him because, listen, I defend everybody's right against self-incrimination and not having their decision to decline to testify held against them.
But that doesn't change the fact that atmospherically, when you have somebody who's saying something happened and then just a complete vacuum on the other side, that it doesn't help Trump's testimony, does it?
No, it doesn't. And, here are a couple of other things to consider. There's a saying in the law, it's actually a Latin phrase, res ipsa loquitur, translation, the thing speaks for itself. What is the thing? Donald Trump paid Stormy Daniels $130,000 to shut her up so she wouldn't tell the story about what happened in that hotel room. You can bet the jurors aren't foolish enough to believe Donald Trump paid her $130,000 because she was going to make up an encounter with Donald Trump. That doesn't make any sense. Here's another thing. This may sound too cute by half, but if you really want to call a witness to rebut what Stormy Daniels said, how about you put Melania on the stand? Here's why I say that. Recall that Stormy Daniels said during the encounter in the hotel room with Donald Trump, the subject of Donald Trump's wife came up. And what did Donald Trump tell Stormy Daniels, according to her testimony? He said, don't worry about her. We sleep in separate bedrooms. Oh, well, If Stormy Daniels is making that up, then Donald Trump could call to the stand Melania, and she could testify, no, we slept in the same bedroom, so obviously Stormy Daniels is making that up. Do you think Donald Trump is going to call Melania to try to rebut or undercut the credibility of Stormy Daniels?
Yeah, I don't think so.
Probably not.
Yeah.
Probably not.
No, the Trump team also tried to amend the gag order now that Stormy Daniels' testimony had concluded, and that was to let him be able to speak freely about her, which is Trump speak, for attack her. This was summarily rejected by the judge. He ordered that he wouldn't modify the gag order, and he cited how witnesses who've not yet testified would see how witnesses who had testified would be treated afterwards. His Judge Merchan's quote was, "Your client's track record speaks for itself." Can I have your response to that?
Yeah, can you imagine if Judge Merchan said, you know what, I'm going to prohibit Donald Trump from attacking witnesses until they complete their testimony, and then Donald Trump can retaliate for the fact that they testified against him. It sort of defeats the purpose of a gag order.
Right, isn't the whole point so that preventing him from being able to attack witnesses wouldn't allow him to impugn the integrity of the trial or put in jeopardy the integrity of this trial by preventing these people from coming forward to testify? Isn't allowing him to just retaliate against these witnesses after the fact the exact same thing as allowing him to attack them beforehand? Doesn't it still prevent these people from wanting to come forward, knowing that whether it's before or after, they would still be attacked?
Yeah, to preserve the due administration of justice, to keep this kind of stuff from leaking into the jury box and infecting the jury's deliberations, you know, the judge is making the exact right call. No, Donald, you can't attack witnesses before, during, or after their testimony. And I think, you know, a sure sign that this was an easy call for Judge Merchan when the defense said, well, Stormy Daniels is done testifying, so we want the gag order modified so Donald Trump can now attack her for what she said. I mean, I don't think it took much time, at least based on what I can glean from the reporting, between the time the defense made that motion or renewed the motion to modify the gag order and the time that Judge Merchan shot it down.
No, it was just a few minutes, so it didn't seem like Judge Merchan had to dig real deep for this one. Finally, let's finish off with this. Now that we've had a few witnesses complete their testimony, where are we at in terms of this trial, and how long do you expect that the remainder of the witness testimonies and the cross-examinations are going to take?
Yeah, so it's interesting. Just a couple of days ago, the prosecution team said they're intending to wrap up their presentation of the evidence, what we call the government's case in chief, within 2 weeks. Now, given the McDougal development, it may very well be that they're going to be done early next week. So it does feel like things are accelerating. But let me tell you, Brian, that's par for the course in so many criminal trials as prosecutors continue to assess how much evidence they've presented to the jury, you know, over the course of the first several witnesses who have testified, how persuasive it was, how little damage the defense did, undermining the credibility of those witnesses. And then, as I say, we often begin jettisoning witness after witness. You know, there's a saying, when you investigate the case in the grand jury, you investigate broadly, but when you get to trial, you prove your case narrowly. And it sounds like the prosecution's case is narrowing at this point.